Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. We are now at stage 17 of the 18 stages of a civil case in India. In this video, you will learn what an appeal is, when and where a civil appeal can be filed, the complete procedure and time limits as per the CPC and the latest amendments, and what happens after the appeal is admitted. What is an appeal in civil law? An appeal is a statutory right that allows a party to seek reconsideration of a decree or order of a lower court by a higher court. It is important to understand that an appeal is not an automatic right, unless the law expressly provides for it. Under Sections 96 to 112 of the Civil Procedure Code, 1908, CPC, civil appeals are generally divided into three types. A first appeal, under Section 96 CPC, is filed against an original decree of a trial court and is heard by the district court or the high court. A second appeal, under Section 100 CPC, is filed before the high court against the judgment of the first appellate court, but only when a substantial question of law is involved. Appeals to the Supreme Court can be filed under Article 133 of the Constitution or by seeking special leave under Article 136. Types of appeals in civil cases. A first appeal is filed against the original decree of the trial court and lies before the district court or the high court. A second appeal challenges the judgment of the first appellate court and lies only before the high court on substantial questions of law. An intra-court appeal may lie from a single judge to a division bench of the same high court. Finally, an appeal to the Supreme Court lies from a final order of a high court under constitutional provisions. Time limits for filing civil appeals, Limitation Act, 1963. The time limits for filing appeals vary. A first appeal must generally be filed within 30 to 90 days from the date of the decree. A second appeal must be filed within 90 days. While appeals to the Supreme Court must be filed within 90 to 120 days. Courts may condone delay under Section 5 of the Limitation Act, provided the appellant shows sufficient cause. Procedure for filing a civil appeal. The appeal process begins with drafting a memorandum of appeal, which includes the grounds of challenge, facts of the case, and legal arguments. This document must be signed and verified as required under the CPC. It is then filed along with essential documents such as a certified copy of the decree or order, a copy of the judgment, the court fee, the vakalatnama, and, if needed, a stay application. After filing, the appellate court examines the appeal at the admission stage. It may either admit the appeal or dismiss it at the preliminary stage. If admitted, the court issues notice to the respondent. The record from the lower court is then called, and the matter is listed for hearing. Both parties present arguments. Additional evidence may be allowed only in exceptional circumstances as per Order 41 Rule 27 CPC. Finally, the appellate court may confirm, reverse, or modify the lower court's decree. It may even remand the matter back to the trial court for retrial or pass any order necessary in the interest of justice. Important provisions related to civil appeals. Several provisions of the CPC and the Constitution deal with appeals. Section 96 governs first appeals, while Section 100 deals with second appeals on substantial questions of law. Order 41 CPC lays down the appeal procedure. Sections 104 to 106 CPC specify which orders are appealable. Appeals to the Supreme Court arise from Articles 133 to 136 of the Constitution. Additionally, Sections 13 to 14 of the Commercial Courts Act, 2015 provide for fast-track appeals in commercial disputes. As part of procedural reforms, some high courts have also introduced mandatory e-filing of appeals and digital case tracking in 2023-24. Landmark judgments on civil appeals. In Banarsi v. Ramphal, 2003, the Supreme Court held that the appellate court cannot grant relief that has not been claimed in the appeal. In State Bank of India v. S.N. Goyal, 2008, it emphasized that fresh evidence should be permitted only in rare situations. In Narayan Bhagwantarao Gosavi v. Gopal Vinayak Gosavi, 1960, the court clarified that an appeal is a continuation of the original proceedings and not a fresh lawsuit. Practical tips for appellants. Always file the appeal within the prescribed time and ensure that all required documents are attached. Grounds of appeal should be specific and concise. Avoid irrelevant or repetitive points. Seek proper legal advice before appealing. If execution of the decree is about to begin, file a stay application without delay. Summary. Civil appeals are governed by Sections 96 to 112 CPC and may lie before the District Court, High Court, or Supreme Court. The time limit ranges from 30 to 120 days, depending on the level of appeal. Order 41 CPC governs procedure. Appeals may seek reversal, modification, or remand of the decree. Several courts now encourage or mandate e-filing of appeals, as per recent reforms. If you found this information useful, please like, share, subscribe, and press the bell icon so you can receive more such important legal videos in time. I assure you that I will continue to provide accurate, lawful, and research-based legal information on various topics through this channel. Your support means a lot to me, so I humbly request you to stay connected with this channel. By joining this channel, you can also receive special legal information and membership benefits. Thank you very much for watching this video. See you soon in stage 18 of our civil case series. Jai Hind, Jai Bharat.